Some good news for VW customers who've had to pay arbitrary road, admin and handling fees. The National Consumer Tribunal has ruled fees charged on consumer credit agreements are unlawful. The German car maker now has to refund customers and submit an audit report to the regulator. National Credit Regulator Manager for Investigation and Prosecution and Karin Duploy joins us now to discuss this. Good evening, and thanks very much for your time. Perhaps before we get to your ruling, does it only affect Volkswagen Financial Services?
This ruling only affects Volkswagen Financial Services. We, however, did detect this type of conduct under other credit providers as well, and the necessary action has been taken.
And how widespread is this practice, really?
We conducted an industry-wide investigation, and there's more than one credit provider that were identified. So compliance notices were issued against the credit providers who is acting in this fashion. And then there is more than one application pending before the National Consumer Tribunal currently for this type of conduct under credit providers.
Mm-hmm. Now, how much money are we talking about?
It's difficult to put a monetary value to the amount that needs to be refunded.
But for individual
what we noted for individual consumers, it ranged from 2,000 to 5,000 rand that's being charged illegally on the agreements that's been entered into.
Over each agreement, not per month or per a year, but in terms of each contract
it's
that has been signed.
In terms of each contract, yes.
So typically, what do dealers and financial service companies do to kind of hoodwink, if you like, sort of consumers to actually sort of get into these kinds of contracts?
What we found is that there's a fee that's included in the pre-agreement statements of the credit providers. They'll cover the fee as a handling fee, an administrative fee, or on-the-road fee. That's what they call the fee. But it's not a fee that's allowed in terms of our Act. So it's an illegal fee that consumers are entering into when they sign these credit agreements. So they disguise the fee as something different. Mm-hmm. We also found during the hearing of this matter at the tribunal that they could not explain to the tribunal exactly what these fees were for. There's no service, there's no product offered. It was simply a fee added to the fee that the consumer were obliged to repay.
Is it a once-off? I think for the sake of our viewers, just so that they can understand if they in future sort of get onto deals like these. So there you go. You want to buy a car. You want a financial services company to finance your deal. So over and above the money that they charge you, the amount they charge you for the car, they then say, we'll put in petrol. And they say, we'll register your car. And then they add a whole lot of services. But then where you could have, let's say, paid for this in hard cash, you now have this burden that goes for like the duration of the contract. Is that what we're talking about here?
The Act allows for certain fees to be added onto the credit agreement. It's very clear that credit providers are allowed to add initiation fees, extended warranty fees, fueling costs, and licensing fees. The fees that we're talking about in this instance is handling fees that were added, on-the-road fees that were added, administrative charges that were added, over and above the fees that's allowed in terms of the Act. So it's mainly this illegal fee that the regulator took issue with, and that was the reason for the compliance notice issued. There is fees that's prescribed in terms of the Act that the credit providers are allowed to charge.
Now, given that this had been going on for years. How do people then in future protect themselves against this sort of practice in case there will still be some unscrupulous people out there who may just continue even though you've made this ruling against this particular financial company?
In terms of the Act, credit providers are obliged to provide consumers with pre-agreement statements and quotations prior to entering into the credit agreements, and all the fees must be disclosed on these pre-agreement statements. So consumers must carefully peruse these statements to determine whether there's any unlawful charges, and if there's any unlawful charges that's not provided for in terms of the Act, we request that consumers report that to the credit regulator for us to be able to investigate it and take the necessary steps against these credit providers.
But how many or what percentage of people do that? In other words, scrutinize these contracts? Because often people are just anxious to get the deal, get their car and drive it.
Look, we conduct compliance monitoring exercises into the industry as well. So we conduct a random compliance check on credit providers. So we do monitor the industry to see whether this type of overcharge occurs somewhere, and then we'll take the necessary steps from our side. But as a consumer, there's an obligation on them as well to check their pre-agreement statements.
And quickly, was it the first time that you've made a ruling of this nature?
Of this nature for this specific contravention. VW was the first credit provider who took the compliance notice that was issued against them to the Consumer Tribunal to have it set aside. So this is the first ruling, but it's not the only credit provider that's been issued with a compliance notice. And we are monitoring the industry to see whether there's other credit providers against who action must be taken.
Okay, thanks very much for coming through this evening. National Credit Regulator Manager for Investigation and Prosecution, and Karine Duploy.